The owners of the volcano in New Zealand that erupted disassociate themselves from any responsibility regarding the safety of visitors. The eruption of White Island Wakari volcano in 2019 triggered a discussion about tourism related to risky natural phenomena. The owners of the New Zealand volcano that experienced a deadly eruption in 2019 denied claims from the country's workplace safety regulatory body, which asserted that they were ultimately responsible for the management and supervision of activities on the island, including the safety of visiting tourists. The eruption of White Island Wakari volcano on December 9, 2019, resulted in the tragic loss of 22 tourists, including 17 of Australian nationality, and left 25 other people injured. This led to a renewed questioning of the regulation of tourism in hazardous natural environment in New Zealand. Last Thursday, an extensive legal process against Wakari Management Limited, WML, concluded in the Auckland District Court. WML is a company jointly directed by the three brothers who own the active volcano located on the east coast of the North Island. It began with heartfelt testimonies and vivid accounts from tourists who survived the volcano eruption, many of whom were cruise passengers. These narratives highlighted that they were unaware of the risks they would face when approaching the Wakari crater. Investigators from the government agency WorkSafe filed charges against a dozen entities for breaches of health and safety laws following the tragic incident, involving tourism companies, scientific institutions, and the island's owners. 6 entities admitted their guilt before the volcano-related case went to trial. However, despite the investigation being considered the most complex in New Zealand's history, the case against the remaining parties began to weaken once the trial started in July. 5 companies or individuals who had maintained their innocence had their charges dropped after the prosecution's evidence was presented last month. With only one defendant remaining, in this week's closing arguments, the debate revolved around whether WML, the company established to grant licenses to tourism companies on the island, exerted active control with legal responsibility for safety in the operation of these businesses on its premises, and whether the measures they took fulfilled all their obligations. According to prosecutor Christy McDonald, the central aspect of the case revolved around financial matters. Andrew, James, and Peter Buttle received $1 million New Zealand dollars, equivalent to 10,570,000 pesos, in fees and commissions for the licenses their company granted to tourism operators, she informed the court. The profits were not directed towards improving management or understanding the dangers associated with tourism on an active volcano, McDonald stated. The company had legal responsibilities toward the tourists whose payments sustained their business, as they were committed and active administrators with the authority to prevent operators from using their premises. However, James Kearney, WML's lawyer, argued that the volcano owners had established the company for the sole purpose of managing the financial aspect of licensing, and that having a commercial interest was not a cause for shame. The allegations related to the economic aspects in this case do not significantly contribute to addressing the fundamental issues that Your Honor must consider, Kearney stated, referring to the prosecution's comments during the trial suggesting that the owners had prioritized profits over safety. The company lacked active supervision over daily operations on the island and had no presence on or around Wakari. Its sole purpose was to grant access licenses to other companies, as indicated. Kearney stated, Wakari is not a business but an island. Was it dangerous? Yes, WML doesn't deny it. Granting access permits to an active volcano is akin to what property owners do by allowing tourists to access hazardous natural areas, a common practice throughout New Zealand, they stated. According to Kearney, the licenses granted to tourism operators did not imply that WML had a continuous role in island operations. Furthermore, he pointed out that the company had fulfilled all legal obligations imposed on landowners, in any case. The volcano-related trial represents the most prominent test to date of the extensive reforms implemented in New Zealand in 2015 in its health and safety labor laws. These reforms, the most significant in 20 years, shift the responsibility for workplace risk management to those who run a business or undertaking, requiring them to be proactive on safety matters rather than relying heavily on regulators. The legal amendments, which harmonized New Zealand's legislation with that of Britain and Australia, emerged as a result of the tragedy in which 29 workers lost their lives in the Pike River mine explosion in 2010. The central focus of the Wakari trial was to determine whether it was justifiable to consider WML as a responsible entity, and if so, whether it failed in its responsibilities. The company and its directors, whose individual charges were dropped last month, seemed to hold the belief that they had no legal responsibility, as indicated by McDonald. WML is essentially blaming everyone else, she commented. Throughout the case, the preparedness of a scientific agency and the management of local emergencies in relation to an event of this nature were closely examined. That it was deemed risky to suggest that a single private company should take on the responsibility of assessing the social risk associated with an activity, Kearney noted. After nearly 2 months of evidence presented by the prosecution, Kearney's statements on Thursday marked the first occasion on which the island owners presented an argument against the charges. Due to the number of fatalities and the shocking nature of the disaster, which attracts global attention, there was a threat of hindsight bias in seeking accountability towards anyone, Kearney explained. This case was considered a traditional example of landowners allowing access to their property for adventure activities. Judge Evangelos Thomas, responsible for ruling on the volcano case, announced that he will deliver his verdict on October 31st. The 6 parties who admitted their guilt in the charges brought against them will be sentenced in Wakatan, located in the Bay of Plenty and near Wakari, on October 19th. Among them is the tourism company that transported visitors to the island by boat, where 2 of the company's guides lost their lives due to the eruption. These companies could face fines of up to 1.5 million New Zealand dollars, equivalent to 15.8 million pesos, if found guilty.